Good afternoon, everyone. Welcome to our Harris-Bricken Cannabis Litigation Trends Q&A webinar. It's a lunchtime hour webinar where we're going to answer questions about litigation trends in the cannabis industry and hemp industry as well. Before we get into it, I want to announce that next month, Thursday, September 17th, also at 12 to 1, Harris-Bricken will be hosting yet another free webinar. It'll be a hemp CBD Q&A webinar. I will be moderating and a panelist along with two other attorneys from Harris-Bricken, Daniel Short and Natalie Bougenes. So don't forget, if you go to the Canna Law blog, you'll be able to register for that webinar. Today, I want to introduce our panelists and then just jump right into questions. Please do not forget, if you have questions, ask them in the chat box and we will try to answer those as well. I'm Griffen Thorne. I'm an attorney with Harris-Bricken in our Los Angeles office. Before coming to this firm, I was an IP, intellectual property litigator at a very large national law firm where I litigated dozens and dozens of intellectual property and commercial litigation disputes. Today, I focus mostly on contract drafting and negotiation, but I still do some litigation. On the panel with me is Jihi An out of our Portland office. Jihi was at a large international firm before coming to Harris-Bricken, where she did also a lot of intellectual property and commercial litigation, and today litigates tons and tons of cannabis disputes out of our Portland office. And finally, last but not least, we have Jesse Mondry, also out of our Portland office. Jesse came to Harris-Bricken a year or two ago from a boutique litigation firm in Minneapolis, litigating commercial disputes on behalf of Fortune 50 companies. So we have a team of very sharp litigators today to answer questions and talk about trends in the industry. I'll start out with a sort of a softball question, and this one I'll pose to Jihi. What are we seeing over the last few years in terms of cannabis litigation? What are the trends?
Sure, thanks, Griffen. Just briefly, I want to introduce myself again. My name's Jihi. I primarily work out of Harris-Bricken's Portland office, but I am barred in all 3 states along the West Coast, and I did spend the majority of my career in LA, so I have the opportunity to work with clients all up and down the West Coast. I also want to reiterate that we definitely appreciate everyone tuning in and hope most, if not all of you, get a few takeaways from today's lunch hour. So to answer that question, I think what Jesse and I and Griffen have been seeing during the past couple years working at Harris-Bricken is that the cannabis industry is definitely maturing and the relevant litigation is maturing with it. So before, especially when I first started here, we were predominantly dealing with kind of regulatory and compliance issues for our clients. So we were advising them on how to set up like a solid compliance plan so that violations could be avoided in the first place, or if a violation did occur, kind of how to navigate that agency litigation process of answering the charging document, working with your case presenter, preparing for the administrative hearing if it comes to that. But now, kind of in addition to that type of administrative litigation, I would say our cannabis clients are basically confronting the same issues all of our clients are facing in any other commercial industry that we service. There are definitely a lot of partnership type disputes, breach of contract disputes, fraud claims seem to be on the rise, and so on. And so we definitely hope to get into a little more detail about a few of those industries and claims based on the questions that have been submitted already. And hopefully there's something for everyone.
Jesse, is there anything you'd like to add to that?
No, I think that's a pretty good summary of where we're at in the last years and what you're seeing. I'd add that we're seeing a lot more, I think, partnership disputes and disputes between members and limited liability companies as well.
Yeah, and I'd like to add too that, Jihi mentioned administrative enforcement litigation, which is very different from civil disputes, which are usually between companies or between members of companies, so on and so forth. In an administrative dispute, that's between the licensed cannabis entity and the regulatory authority, for example, the Bureau of Cannabis Control in California. And in Oregon, where the cannabis laws are much more mature than California's, you do see a lot of administrative litigation, whereas here it hasn't really kicked off to the same extent. There's been very few, at least publicized cases. So that's that hasn't hit yet, and we'll get back into a little more today. And that kind of leads me into the next question, which is the fact that, currently in the United States, there's dozens of states that have legalized cannabis in one form or another. None of the two laws are the same. They always look different. The legal and regulatory structures in each state are very different. What may stand in California is not going to stand in Oregon or Nevada. So given the difference in laws between each state and the fact that a lot of businesses are operating or even established in multiple states, what are some common issues, Jesse and Jihi, that you're seeing with regard to multi-state litigation?
Yeah, Jesse, if you don't mind, I can kind of start off with that one. So, I think it's really common to see in this industry that players started in Washington and then they kind of moved into Oregon or vice versa. And now they have business dealings in California. But generally, the type of litigation that we're seeing, civil litigation that is pretty similar among, the entire West Coast. So like we've already kind of talked about, I've definitely seen a lot of breach of fiduciary duty actions, which could potentially differ based on what state you're in. But, it boils down to there's a dispute between members or between partners. And then there's also breach of contract actions, I would say primarily with supply agreements where, one party fails to deliver or conversely, one party fails to pay. And despite the different rules of each state, these claims are rampant pretty much in every state. And yeah, that's what I would say.
This is Jesse Mondry. Hi, nice to meet everybody. I would agree with what Jihi said. And I think one of the problems that multi-state operators are confronted with, as Griffen pointed out, is this sort of patchwork regulatory system and the differing laws, rules, and regulations of each state. And, not only has that increased the sort of opportunity cost to invest or buy into this business, but it's greatly sort of increases the risk for multi-state operators in terms of the administrative side, because it's hard to have a comprehensive multi-state program. And then on the business side, it's hard to have comprehensive contract documents that are going to work in every state. There's a lot of things you can do for multi-state operators in terms of the way you structure operating agreements, the way you can do terms and conditions for sort of Article 2 UCC sale of good issues. And so a lot of that really, I think, should be handled up at the front end by, cannabis companies working with folks like Griffen so that they, hopefully can avoid or minimize the need to work with folks like Jihi and myself on the litigation side. I think the other thing we're seeing in terms of the multi-state part of things are sort of the increase in class actions, which, right now, I think are more on the hemp side when you're in federal court, because you can't really bring those in terms of recreational marijuana. But I think multi-state operators, as the cannabis industry increases and matures and gets larger, they're going to become targets for plaintiffs' class action lawyers. And I think we've seen a few of those cases, and we've seen a fair amount of those cases now within the hemp CBD field.
We had another question come in from the audience just now about employment law cases and whether either of you have seen a trend in employment cases specific to this industry. I know there was a big 10th Circuit case recently, about a year ago, that was appealed up to the Supreme Court saying essentially that certain federal labor laws will apply to cannabis businesses despite that they're federally illegal. Are either of you seeing any sort of uptick in employment law disputes yet, or do you expect to see that in the horizon?
I would say I definitely expect there to be, especially during this, COVID-19 crisis where, a lot of employees are bringing kind of workplace safety claims or leave claims and things like that. So to be honest, I don't have a ton of experience in employment law, but it's certainly something that I would expect to see rise as the months go by.
This is Jesse, and I think it's just like any other business where you've got employees, you're going to have these kinds of claims, and cannabis is no different. Earlier this morning, I was on the phone with a client who's facing a potential BOLI claim, or Bureau of Labor and Employment here in Oregon, and it's essentially a disgruntled employee who's made some allegations, and so I think these are the kinds of claims you're gonna see this would happen to involve the person who is a grower at a grow operation and, has some problems with their supervisor. And so, and from a litigation perspective, and I'm not an employment lawyer as well, but this really underscores the need to sort of bring somebody in and establish, policies and procedures manuals, have an HR department, have a system that's set up to deal with these kinds of complaints and handle them in compliance with federal and state law. At the federal level, I think, you're looking at the same kind of Title VII claims that you would in any other industry. You can't discriminate on a person on the basis of, race, religion, gender, these sorts of things. And so those are just going to be applied across the board to marijuana. Is that answering the question?
Yeah, I think so. And we also had another interesting question come in just now from the audience. We see a lot of cannabis companies, especially the bigger ones, the multi-state operators, hiring teams of in-house counsel to guide them on things like M&A, corporate contract drafting, things like that. Are we seeing any sort of trend so far where in-house litigators are being brought in? We will see that in established industries where there's an in-house litigation team, but is that happening yet in your experience with cannabis?
I'll go first on this, G. I haven't seen that much. Most of the cannabis clients that I have and the companies that I've dealt with, whether on the hemp or marijuana side, aren't at the really the size, I guess, in one sense, where there's a need to bring in a lawyer just to focus on litigation. And really, most of them aren't in that many sort of disputes where I think it makes financial sense to have a full-time litigator in there. The kind of companies that have full-time litigation departments or teams are really, pretty enormous companies that might have a global reach where it makes sense to sort of have an in-house team of 5, 10, or even 30 litigators on here. But even those kinds of companies often will contract out, large cases because it simply doesn't make sense to keep, a team like that on staff for sort of the lulls and the ebbs and flows of litigation. But that's what I've seen so far.
Yeah, I mean, I would completely agree with Jesse's kind of evaluation of that. We have clients who definitely, come back with different types of disputes for us to handle, sometimes multiple times a year. But it's probably, again, not to the level where you would need a dedicated in-house litigator to kind of, oversee all of the disputes and then potentially farm out work. I think as the cannabis industry does continue to see more litigation and continue to, bigger companies continue to face more claims and cases against them, that's definitely a trend that we will see, but I don't think we're there yet.
So before I jump into my next pre-submitted question, we did get a final question I think would be relevant to that series of questions, which is, what is the state of the illegality defense to cannabis contracts? And just so everyone knows, cannabis is federally illegal still, marijuana at least. And because of that, sometimes people will try to raise a defense to a breach of contract claim by saying, hey, look, court, this contract is illegal, don't enforce it. I can say that in California, there's a statute that says that that's not a defense in so many words, but there's always a risk in going into federal court that that the contract could be held invalid because it's federal law that's being applied. And I don't know if one of you wants to comment on Oregon. Jihi, maybe you can mention anything specific in Washington about the illegality defense in those states.
Yeah, I mean, I think it's pretty similar for Oregon and Washington. Jesse, correct me if I'm wrong, but plenty of cases have gone forward that involve cannabis, and I haven't really been seeing the illegality defense even being brought up at this point anymore. So that's kind of my take on it.
Yeah, I would agree with both of you. I think it's still a valid defense in federal court, and I think anybody who's involved in marijuana should avoid federal courts. I think you're going to keep seeing those getting kicked out because judges, it's a pretty easy out for a case, and you're asking a court to rule on a contract dispute that involves an illegal controlled substance. And but at the state level in Oregon, I don't think we don't see the illegality defense at all anymore. And these kinds of cases are routinely litigated and even tried here. And I think the same is true in Washington. So I think the illegality defense is sort of a no-go from a state court level, but very much in play at the federal level.
Okay, well that pivots right into my next question. It's a two-parter. So first, what kind of litigation-specific clauses do you see negotiated into a company's formation documents? And second, what kind of contract provisions, substantive provisions, are the most litigated in terms of cannabis companies? Jesse, you want to start out with this one?
Yeah, I'll try to take the first part and see what I can say to the second part and see what G has to say on that. But I think at the outset, the kinds of litigation provisions people need to be thinking, whether you're going to be operating in one state or multiple states, and whether you have, just a couple of members LLC between, you and your best friend, or whether you've got outside investors, is the kind of things you need to be thinking about are venue provisions. If there are disputes, where are these disputes going to be heard? And in terms of that, you want to think about, well, do we want to have alternative dispute resolution clauses? Do we want to require mediation before you can go to court? Do we want to say, let's just go to arbitration? And for years in cannabis, and cannabis attorneys would always strongly recommend that you have an arbitration provision in part because of the illegality defense. But that's a still pretty relevant consideration today when you look at the time frame of state court litigation, the uncertainty of it, the kind of discovery burdens you can have in state court litigation. So considering sort of venue, that's question number one: where do you want to litigate disputes, and how are you going to litigate disputes? And I think the second part that you want to think about is jurisdiction. You want people to consent to the jurisdiction of that venue. The idea here is to avoid litigation later about whether you can haul one of your partners in from out of state, or where you've got to do this, and to put these things right in there. That's going to go along with choice of law clauses. What law is going to apply? This is easy, generally if you've got an Oregon operating agreement operating in Oregon, but it never hurts to have that, included in there. All of these things are sort of designed to eliminate uncertainty and essentially, motion practice early on in litigation. I think another important point is, so people don't often think about this, would be statutes of limitations, which, if you've got the potential that the dispute could, if you've got a multi-state contract, or you're dealing with people out of state, and you get into some dispute, regardless of where it might be heard, the question of what statutes of limitations apply. And what I mean by that is that you'd think that just adding a clause in your contract that says, well, Oregon law applies to these disputes, means that the Oregon statute of limitations applies. And that's not necessarily always the case. And that's because of, not to get sort of too complex, but it's sort of there's a doctrine under federal law called the Erie Doctrine that says, look, a federal court is going to apply a state's substantive law, but federal procedural law. And most states have something called a borrowing statute, in which they do sort of a similar analysis. And so then the question is a statute of limitation substantive or procedural? Well, this can be argued a lot of different ways. And I've had clients spend a lot of money arguing these kinds of points. But this is another thing that could be, sort of resolved up at the front end, I think. And so this is, these are the kinds, and I think, I guess the final point is attorney's fees provisions. You want to consider, do you want to have an attorney's fees provision in there? On the one hand, it sort of makes it so that sort of, well, if a dispute does arise, you are going to be able to sort of recover your cost of that. The other hand, though, an attorney's fees provision might say, well, it gives people an incentive to say, well, I'm going to go ahead and bring this dispute. I'm going to fight about this because I can always get my attorney's fees. But if you've got, a situation in which somebody might have to spend, $100,000 on $1,000 on a $50,000 claim, that changes the calculus for litigation. So these are things that you want to think about in terms of when you're doing your operating agreements, when you're doing formation documents, and whether you're dealing with, and you really want to think about these in other contracts as well. When you're doing, if you're just sort of delivering cannabis products within your state, what kind of terms and conditions do you want on your purchase orders? If you're receiving them, if you're sending hemp or CBD out of state, or if you're working with a company that's for licensing the manufacture of your CBD products, or labs that you're doing your testing with. These are the kind of things that you want to work with somebody like Griffen on at the front end. It'll save you a lot of time and money on the back end. And now I forgot the second part of the question. So.
Well, actually, if I could just piggyback off of what Jesse has been talking about, I know the question was specific to like litigation provisions, but just as a general matter, my biggest piece of advice, and I think Jesse's also what he's alluding to, is just to spend the time to create really solid corporate documents, like your operating agreement, and maybe even like your employment or independent contractor agreements if you use them, just because having that set of really good checks and balances, and then making sure to abide them is just going to put everyone on notice of their responsibilities and make it less likely that, you know, issues are going to come up down the line. The more provisions you have that kind of provide, you know, certain conduct will be a breach, or if a breach does happen, it's going to result in these types of damages and these types of remedies to the companies or to your other members. That is all going to kind of up the ante in terms of when a person is considering maybe mismanaging a company or, you know, engaging in other kind of improper conduct. Similar for breach of supply contracts. Unfortunately, I get so many requests to file lawsuits on behalf of, like I said, someone who's owed product or someone who's owed money. And when they come to me, there's literally nothing in writing, or, you know, the documents are pretty shafty. And so that's not to say that oral contracts aren't enforceable. They are, but claims involving written contracts are just so much easier to prove, meaning resolution is typically a lot faster. So if you kind of do the work on the front end and get your sales contracts, get your terms, get your invoices, your receipts, all of that in order, it's just so much easier to put in that work in the beginning, so you're not trying to cobble together the history of a business relationship from like phone calls and text messages down the line when a dispute does come up.
Yeah, and I'll piggyback on that a little bit. Oral contract, handshake deals, whatever you want to call them, it's a terrible idea in 2020. I know it's expensive to have someone put together a contract, but it will save tens and tens of thousands of dollars in a dispute if you have a contract, because it takes literally, you know, very little effort to authenticate an actual contract. But for an oral contract, you have to prove to the fact finder that the agreement was what it was. So the amount of effort it takes litigating an oral contract is immense. And in California, the statute of limitations on an oral contract claim is much shorter. In terms of things you would want to add to a contract to avoid litigation, I could probably do a 5-part webinar on just that. But I think the top thing that should be in people's minds when drafting these contracts, top 2 things, equal importance, is federal illegality and the concept of changes in law or changes in enforcement priority of the federal government. You know, we all know that it's federally illegal, but the federal government isn't really doing anything against the state licensed cannabis industry. But, you know, nothing is stopping that from changing on the drop of a dime. And we want to have contracts where parties, if there's a change in enforcement priorities or whatever it may be, have the right to get out of the contract or reform the contract to comply with these new changes in law. Also, because of federal illegality, there's very few situations where I think it's a good idea to not have an arbitration clause, or at the very least to not have a mandatory state court provision. Someone asked in the forum whether we should use out-of-state forum selection clauses. To me, it doesn't really make a lot of sense to do that, because cannabis is so highly regulated in specific states, and contracts usually take into account the regulatory requirements. So it doesn't make a lot of sense to set the choice of law in another state. And many times the efforts to do that really don't go very far anyway. Even having the litigation or arbitration in a different state can be problematic. I had a client once who wanted to have disputes resolved back east where everybody was located, but we instead allowed them by video proceeding, because it would just be simpler to have a California arbitrator deciding issues of California law, and probably better. So these are all things that are really important to consider at the front end. And while the investment in a very good contract can be significant for a small business, it can save 5 or 6 figures in litigating a dispute. Just sort of as a personal anecdote, I mean, I had a case once where the arbitration clause wasn't well drafted, and we spent nearly a year debating and fighting in court as to whether or not it happened. And that's all something that can be avoided if the contract is very clear. So it's very important to get this stuff right at the beginning. Changing topics a little bit, we've got a lot of questions both beforehand and in the chat about COVID-19 and the effects in the cannabis business, in the cannabis industry, excuse me. As everybody knows, a lot of the federal relief wasn't available for cannabis businesses. When I say cannabis, I mean marijuana, although some hemp companies have been able to get relief under these new federal laws. But in terms of litigation, things like force majeure clauses, other kinds of COVID-19 disputes, what kind of trends are you seeing, Jihi and Jesse, and anything that was sort of unanticipated or that we didn't think was going to happen?
Yeah, that's definitely a great question, just because, obviously this year has been completely nuts and just really unprecedented in a lot of ways. I think we talked about this before, but civil courts are definitely still seeing tons of filings, especially new cases that are actually coming out of the circumstances that COVID-19 has created. So like you mentioned, force majeure provisions are definitely being much more litigated at this point. Just in case anyone's unfamiliar, force majeure provisions refer to the occurrence of an event that's kind of outside the reasonable control of a party and prevents that party from performing its obligations under contract. So, that type of provision doesn't usually come up just because a party's ability to perform its obligations under a contract is usually within its control. But obviously circumstances are different now, and not everything is under, business owners' immediate control at this point. So yeah, there's definitely an uptick in those types of cases. Like we talked about before in the employment context, leave cases, workplace safety cases are definitely seeing an uptick in filings. And aside from these like new kinds of cases, generally litigation in the cannabis industry it seems to be still going strong because of these kind of handshake deals and poor documentation situations are still pretty common in the industry, unfortunately. Just to kind of give a breakdown of how the courts are looking at this point. So these new cases, and I've blogged about this before, they're just adding to the strain that most courts in the country have felt for a really long time. So I think Griffen and I have talked about this, but cases in like the LA Superior Court easily take like 2 to 3 years from start to finish. A lot of the time, even longer. Jesse, in my experience in Oregon, isn't much better. I would say at least 1 or 2 years. Jesse, I don't know about you, but that's how it's been looking for me. And so since the courts were already so backlogged and now they're seeing this kind of new rush of cases as well, we fully anticipate that the courts are going to work even slower than they have been. And this is obviously going to have different effects on different litigants or future litigants, right? So it really comes down to where you are in the process. If you were essentially kind of at the finish line and you were about to go for trial, you may be facing like a few months delay. I know that some courts have started resuming trials at this point, although, it's a really weird experience because there are all these safety measures that have to be taken into account. And I recently actually read an article that was talking about how a party didn't feel that it received its true day in court because, when they went up to the stand, when they had witnesses testify, they were wearing masks, and they felt that a jury could not really evaluate the credibility of that testimony because of that. And so there are all these like really unique issues that, even going to trial, you're going to face. Like conversely, if you are in a situation where, you're planning to file a complaint or you're evaluating whether to file a complaint against someone, it still may make sense to get that done quickly, just because, a lot of companies are facing the reality of filing for bankruptcy or, just becoming insolvent really quickly. And you don't want to eventually pursue a case and a judgment against a company that is ultimately going to have nothing to offer you. So There are a lot of really interesting considerations at this point, and I would just say, if you have a claim, definitely talk to a litigator or talk to a litigation team about what your options are and, what it's looking like in terms of timeline and cost for you.
Before I move on to a different set of questions, we've been getting a bunch of questions on these 2 points, and I wanted to throw it out there for either of you to answer. Have we seen any products liability cases in the cannabis industry, either marijuana or hemp? And have we seen TCPA claims?
So I can speak to this somewhat. I think let's start with the marijuana side of things. There have been some product liability type lawsuits. I guess most notably recently here in Oregon is that Cura was hit with a $10 million class action lawsuit, which alleges along the lines that their select brand of cartridges did not contain the amount of THC that is sort of on the label. They're actually faced with a similar class action earlier in the year. These, of course, are state court claims, and they're not being brought in federal court. And one of the things to think about is setting even aside the illegality defense, is that a nationwide class action for a marijuana product, I think, is unlikely at this point, really because you can't transfer marijuana products in between state lines. So if you want to come to and say that, well, look, your Oregon manufacturing facility hasn't done a good job here and has put a defective product into the marketplace, it's not necessarily the case that that's going to extend down to your California manufacturing facility. So I think this is one of the reasons we're not seeing giant, you might see these one-off sort of marijuana product liability suits, but you're not going to see them in the same way that you might see, for example, a Volkswagen car recall, which is, this is everybody in the country who's got a Volkswagen or something like that. And of course, the size of the market makes a difference. So there's probably a few other class action marijuana side lawsuits that I'm unaware of. That's quite possible. In terms of the hemp CBD things, we have seen, I'd say close to a dozen or so in the last year. And these generally are along the lines of the sort of, your product doesn't say what it contains, what it says on the label, right? And the person seeks to represent a class of either, wherever the products are sold or within that jurisdiction, and seeks to go forward with it. And these kind of lawsuits, after the 2018 Farm Bill, they are being brought in federal court, and they're being brought in federal courts. And I think California's had maybe 10 or 12 of these kinds of lawsuits. There's been several in Florida. I know Illinois, there's been a couple, New York as well. So these are the kind of things that are popping up, I think, in terms of the product liability lawsuits. In terms of and these are sort of distinct from a defective product. I haven't seen the sort of that sort of the action where your product has caused me personal sort of injury. I think there's maybe some of that out there with the vaping, but that's not as common as like a mislabeling sort of monetary damages type lawsuit, or that you sort of perpetrated a fraud on the consumer by not giving them what you provided, right? And on the other, in the non-cannabis world, you can see this everything from, I think, my prior firm, there was a case involving how much pepper was in the pepper shaker for a number of years, right? I mean, and this is really no different there. And so, that it sort of, goes to the fact that as the industry matures, it's just like any other business here, I think, and you have to start looking at it that way. That's what I have to say.
Yeah, I mean, I know there was a second part to that question involving TCPA claims, which I think are going to be the bane of the cannabis industry's existence really soon, unfortunately. TCPA claims are rampant in every industry. And I think now that, a lot of players are using kind of mass texting campaigns or just other ways, other technologically advanced ways to reach a bigger clientele or audience at once, they're definitely going to run into these types of claims. I would say maybe in the past month or two, I'm aware of maybe a dozen suits that have been filed against, some of our clients and some other players in the industry. So Unfortunately, yes, they're definitely on the rise. I think they're going to continue to rise because, that type of claim is often brought by people who understand that not every company has the wherewithal to litigate. And so they're more looking for kind of a quick payout and a quick shakedown more than, actually trying to effect meaningful change. And so, I've had cases where we get demand letters or we get a complaint and then they immediately just want like a $5,000 or $10,000 payout, which is, real money for a lot of small businesses out there. So I would definitely advise everyone who, is considering these mass texting campaigns or email campaigns to definitely consult with an attorney and just make sure that they are not opening themselves up to that kind of claim because they're a pain to deal with.
I will add a quick plug. Jihi and I will be speaking on a webinar in November on Tcpa and other issues. So follow us on Twitter and LinkedIn if you want to hear. It's not part of the Harris-Bricken webinar series. And I'll add for both. Sorry.
Could you guys define a Tcpa claim real quickly for those in the audience who aren't familiar with the acronym? What is a Tcpa claim?
So Tcpa is the Telephone Consumer Protection Act, and essentially what it does is it allows consumers to sue in some cases if they've received certain communications that were not solicited, essentially.
Right. So the act was first, created to kind of combat like the robocalls that were plaguing everyone, and it's just the definition of what it can encompass has broadened, and people have taken advantage of that, I would say.
Yeah. One thing I think we will definitely see in terms of litigation in the next year and after is something called the CCPA, which is the California Consumer Privacy Act. CCPA is sort of like the European Union's big privacy law. And one of the things that it does is say that consumers can bring claims for up to $750 if a company has their data and that company was the subject of a data breach and didn't take reasonable security precautions. So you'll see class action lawsuits in the near future. We've already started to see them in other industries, but cannabis companies are going to be in a lot of trouble eventually because they, by law, are required to collect detailed personal information about consumers. So it's only a matter of time before we see those suits coming. I don't think any have been filed to date. The law only took effect this year. And to add to Jesse's points about product claims, in other industries, something you see a lot, or in the tobacco/nicotine vape industry is pens that blow up because the batteries might have defect and hurt somebody. Those kind of product liability claims are very, very frequent, and so that's inevitable if it hasn't already happened to cannabis companies to happen nationwide. Maybe the reason you don't see as much publicity is because, as Jesse said, these are usually filed in state court, which in many cases don't have the same kind of publicly available or easily searchable dockets, and they may not be for $20–30 million, and they may be very small in terms of damages. So there inevitably will be a lot of product liability claims for both kinds of companies, but to date, I'm not aware of any sort of monumental cases. With that, I want to talk a little bit about trademark and IP law and some of the trends we're seeing in that industry. Jihi, Jesse, what do you think we're seeing to date in terms of trademark litigation for cannabis companies and hemp companies, both at the state level and at the federal level?
Yeah, I would say trademark infringement litigation is definitely continuing to go strong. They're typically brought in the context of like standalone disputes between competitors, and now in connection with partnership disputes as well. I will do a quick plug for our colleague Allison Malsbury. She does a great job of covering all of the high-profile trademark litigation cases as they're filed, and I would say trademark infringement claims in general typically settle out of court in my experience. And I would say that that is the case for the cannabis industry as well. But in terms of them being brought, I think we're at a point where the industry is arguably a bit oversaturated at this point, and there is a lot more litigation kind of between competitors that has been spiking for a while now. And so more and more we're confronting claims of like fraud and tortious interference and things like that. And trademark infringement is definitely one way in which competitors are asserting their rights, their intellectual property rights, and safeguarding their market space, because players in the industry don't want their competitors to be able to capitalize off of the product or the branding or whatever successful marketing efforts they've built over the years. And so I think we're at a point where trademark litigation is definitely on the rise, and it will steadily continue to be this way for a few years to come.
Yeah, I would add to that I think one of the other things we've started to see and that we're going to see more of, and it's sort of along with the trademark claims are Lanham Act type claims or false advertising claims between competitors in the industry as a sort of offensive tactic to go after somebody who may be selling a competing product or a substantially similar product, who's making certain claims in their advertising that a competitor thinks are out of bounds. And, I'm aware of at least one such lawsuit between competitors in California. And of course, these lawsuits can also be filed by consumers. And so I think that, this is going to be a sort of another one of those federal things. But often if you start kind of adding into sort of copyright cases, you're going to see it, that'll, or a trademark, you might sort of see that bleed into a Lanham Act type case or something like that. And those can be brought at the state level as well. I know that obviously I think you guys could speak on sort of the ability to get trademarks federally for marijuana products and, the difference between that and hemp products. But that's going to be, another significant, I think, areas that for years, I think hemp companies until the Farm Bill were really registering on a state-by-state basis until they were sort of, confident in the ability or they're, in most cases, being denied the ability to get a federal trademark. And so I think as that changes and people obtain federal trademarks, that's going to, increase the litigation as well, because now you're not sort of having to go sort of piece by piece, across different jurisdictions in the country to enforce state-specific trademarks against competitors or people they may be selling online to a variety of states or, variety of jurisdictions.
And just to sort of put a little bit of a spin on this and fill in some of the gaps, being able to get a trademark is very complicated in this industry. Marijuana companies can't get trademarks for things involved. Like, for example, you couldn't trademark a brand of cannabis edibles, right? It just couldn't happen at the federal level because it's not federally legal. Ancillary service companies, even of marijuana businesses, could theoretically get trademarks. So someone who comes up with a software that's used in the industry. With hemp, generally speaking, now that hemp is no longer a controlled substance, trademarks are available, but the USPTO, the Patent and Trademark Office, which is the federal agency that issues trademarks, has basically taken the position that because the FDA says you can't put CBD in foods and beverages, we're not going to issue trademarks for ingestible CBD products. So there is kind of a rub at the federal level, and these things are sort of difficult to get for many of these businesses. Now, at the state level, it can be much easier, although state trademarks are not nearly as valuable because they only provide protection in the state in which they're issued. So, for example, if you had a California trademark for a kind of cannabis good, it's not really going to do you any good in North Carolina, right? It's just not going to do much. So businesses may end up especially multi-state operators may end up having trademarks all over the place, or having some limited federal marks that don't actually involve the plant touching parts of their business. Assuming a business is lucky enough to secure a federal trademark or has any kind of state trademark, what are some strategies that companies can do or sort of should do to protect their trademarks in the event they see someone they think is infringing it?
Yeah. In terms of protecting your trademarks, I truly think companies in the space should kind of consider working with a trademark attorney who's well-versed in the hemp, CBD, cannabis spaces to develop that strategy for protecting their brands. I know that question is kind of asking for like a 5-step list of things that I could do, but unfortunately, it's really hard to provide that just because there are so many unique issues to consider depending on what space you're in. So most recently, for example, we were helping a provider of hemp CBD products, and there are nuances in the FDCA that can cause, obtaining a trademark and enforcing your trademark rights really difficult. And so, I wish I could kind of give more, and maybe Jesse or Griffen can, but I would truly say the best thing you can do to, protect those intellectual property rights that you spent good time and money on developing is to work with someone who knows the product, knows the industry, and can help you protect your specific brand.
Yeah, I completely agree with that. My answer to those kinds of questions is, you should call Allison Malsbury or Natalie Boucheny or Griffen Thorne. Really, yeah. It really, just because it depends on, are you an ancillary service, a secondary provider, a primary provider? What are you trying to do? Where are you selling these products? It's not just a simple, easy answer, I think.
I think one thing to keep in mind too is that for companies with trademarks, if they don't actively use the trademarks, then they could be deemed to have abandoned them. And likewise, if they are aware that third parties are using the trademarks and don't take action to protect their trademarks, then that also could be deemed to be abandonment. So, you could lose a trademark by just essentially letting people use it without consent. So this is one of the few areas of law where you sort of have to be aggressive to some extent, and maybe litigation, it shouldn't be the first answer, but demand letters and things like that, it can really save a lot of heartache in subsequent defenses and abandonment. Sort of a make or break issue. Now, related to trademarks is the concept of patents. Jihi, I know you've done some work on patent cases. Are you seeing a lot of patent cases in the cannabis industry? And if so, what kind of claims are being asserted? What is the standard that it takes to establish patent infringement? And what do these claims generally look like?
Yeah, so to be honest, there are not a ton of patent infringement claims out there currently. I'll start by prefacing that the USPTO has definitely continued to increase the number of patents issued containing the words cannabis or marijuana. So we fully anticipate and are expecting that the growing number of issued patents are going to, they'll inevitably result in more litigation in the future. And kind of like what Griffen was saying, we definitely advise all of our clients who are patent holders that it's more important than ever to, do your due diligence. And if you're a patent owner, actively monitor your competitors, make sure they're not infringing just to protect your rights in that space. I was following really closely the first ever patent infringement case. It's called, I believe it was titled UCAN versus Pure Hemp for over a year. Just because I know that was definitely a case to watch, and a lot of people were kind of looking to see how the court was going to rule on certain issues to evaluate whether they should consider litigation as well. And unfortunately, it had to abruptly end a few months ago because the plaintiff in that case, UCAN, essentially filed for bankruptcy, which acts as a stay or like a pause button in the infringement case. And so that case is unfortunately officially closed as of now, although it can reopen. And like I said, I think a lot of players and attorneys in this space were definitely keeping tabs on it just to see if it made sense for them to bring those kinds of claims as well. But since it's been paused and it's essentially finished at this point, I think it's unclear when those types of claims are going to be brought. They are incredibly technical. I probably should spend more time kind of outlining, how to prove a patent infringement claim in a blog post and not here, just because it's, like I said, it's extremely technical. But I would say for now, I guess we're just going to have to see maybe over the next year or two when that spike is going to happen. I would say it's definitely not happening just yet.
Okay, thank you, Jihi. One of the big kinds of claims we are seeing in general in the cannabis industry, I know we mentioned partnership disputes and breach of contract claims, but we've also seen a lot of fraud claims over the years. Fraud is sort of different from other claims in that, well, I'll let the panel talk about fraud, but what kinds of fraud claims are you seeing specifically? What is the nature of a fraud claim? Why is it different? And do any federal agencies get involved when fraud's alleged?
Okay, well, I'll kind of take maybe the last part first, and I think that so in terms of when does a federal agency like the SEC get involved? Well, they're only typically going to be involved in fraudulent investment schemes, for lack of a better word, or when there's a suggestion that there's being fraud on the marketplace by the placers of memorandum or private placement memorandum or investment opportunities into the marketplace. And there are representations being made there that are either knowingly or recklessly false that were intended to solicit investments. So the SEC, or the federal agencies, sort of wrap it up neatly in that sense, don't really get involved with what you might call sort of run-of-the-mill fraud cases that you see typically in the state courts in the cannabis industry. They're going to be, and I think Jihi can speak to this. There's an SEC action. I think there's an accompanying, might be an accompanying state court case about that recently. But then to turn just to fraud, I guess, or Jihi, do you want to take that part, or I can?
Sure. Yeah, I can jump in. So fraud is definitely, there are so many different types of fraud claims. I would say that in this industry and really any other industry, the most common case is when, someone claims they were fraudulently induced into entering a contract, right? Because a person made a misrepresentation or a material omission of fact, and now they find themselves in an agreement or a contract that they wouldn't have entered had that not happened. So I would say that's definitely the most common type of case. Fraud cases are difficult to bring. There is a heightened, what we call pleading standard. And so, you have to go into pretty minute detail as to, to quote kind of like case law, it's like the who, what, when, where, and how of the fraud that happened, just to bring a viable complaint against a person. And so if you are contemplating bringing a fraud claim, I would say you definitely have to have all of your facts in order, and the attorney is going to have to evaluate whether it rises to the level that it needs to in order to even initiate a lawsuit. Just speaking or going back to kind of what Jesse was talking about, outside of the typical case that I just described, he's right. We're definitely seeing other types of fraud cases on a larger scale. We recently saw a new type of fraud case. I think that's what he was talking about, filed by the SEC against a group of people and companies for what we call securities offering fraud and other violations of the Securities Exchange Act. Offering fraud occurs when a person or an entity makes material misrepresentations or omissions to potential investors in a new company. Most commonly, it's kind of like promising the investors really large guaranteed returns of like 200% on their investment to try to get them to invest in the company. And this complaint kind of outlines how these entities and their principals raised over $25 or $30 million from like 400 investors over a 2-year time period to supposedly finance, the start and establishment of a licensed marijuana farm and CBD extraction facility in California. but then, basically diverted that money for other purposes. So I would say offerings fraud cases have actually been more prominent in recent years. The SEC seems to have like a new focus on that type of case. And now, since this first case has been filed, it looks like the SEC is also starting to look at the cannabis industry specifically for these types of cases. So that one will be really interesting to watch and follow, and we'll definitely be writing about it on the blog.
Yeah, I'd like to add, Jihi mentioned something that's important, which is that fraud requires a heightened pleading standard. And what that means basically is normally with a claim, when you file a complaint against somebody, you don't have to say a whole lot in your complaint, your charging document. It can be very short. Sometimes they're just 5 or 6 pages with the bare bones facts. With fraud, you have to be extremely detailed, because to charge someone with fraud is a pretty heavy allegation. And so courts hold them to a much higher standard. The problem with that with cannabis is that you're putting things in a publicly filed document that theoretically anybody, including your regulators, can see. And so we had a question before this panel come in, which was, is there a risk that cannabis litigation suit may draw scrutiny by state regulators? The answer is, of course. And when it becomes a fraud claim and you have to plead, 5, 10 times as much detailed facts, that really draws a lot of scrutiny. And this is the last question I'll be able to ask. But Jihi, Jesse, have you seen any cases up in Oregon? I know there hasn't been as much enforcement in California, where the Oregon cannabis agencies have said, hey, these claims were made in a publicly filed lawsuit, and now we're going to investigate them, or maybe even file a claim against your company based on these allegations?
This is Jesse. So, I guess I don't have a lot to say on this topic, but it does happen, and the sort of, the evidence is more anecdotal than I think that I can point to a specific thing. But I can tell you that just the other week I was in contact with someone from the OLCC who, because of a publicly filed lawsuit, has decided to conduct an investigation into the entities named in the lawsuit and the underlying going-ons there. And that's because, the Oregon Liquor Control Commission, that's the OLCC, who regulates marijuana for folks not in Oregon, and I think it's the BCC in California. Depending on the allegations of a complaint, the OLCC might take a great interest in it if it looks like there's a risk to harm of consumers, or if there's any allegations that product might be being diverted into the black market, or if there's any allegations that maybe fraud has been committed upon the regulatory agency or in conjunction with that regulatory application in terms of the investors, the investments, and what representations were made. I think the OLCC, at least, sort of, in a sense, sort of jealously guards the cannabis industry up here and takes pretty seriously these kinds of allegations. So I think it does happen, and it has happened where you've got. So that's another reason to go all the way back to the beginning. And when we were talking about what kind of contract provisions do you want for dispute resolution, that's another reason to think about: do you really want to go to state court, or do you want to go to arbitration, which is a more private venue, for example?
Yeah, I have nothing to add. I was going to try to bring it back full circle, just like Jesse did, and say, there's definitely a consideration of whether you really want to air all of that dirty laundry in a public venue and then have it potentially out there for, the OLCC, the LCB to find and then eventually investigate. So.
Yeah, so arbitration, the message of today is that arbitration is vastly superior to litigation, and it's not going to take 3 to 4 years to resolve anyway. So, yes.
In most cases.
Yeah, well, hopefully. So we want to thank everybody for joining. I want to remind everyone that they should look at the chat box. You can see an announcement for our next webinar series on September 17th. Again, I'll be moderating that with some of my other colleagues from Harris Bricken, and it'll be a Q&A on the state of hemp CBD law, both at the state level and with the lovely FDA regulations or lack thereof that we have been experiencing for the last few years. Thank you again for tuning in. I'd like to say thank you to Jihi and Jesse, who have been awesome co-panelists, and we look forward to seeing you next time.